certainly not needed for my benefit. If I lie to you in order to get my hands on your property, we call that fraud or theft. If I lie to you in order to get my hands on your body, we call that no crime at all, unless my deception has to be to the nature and purpose of the act that I have in mind when I tell the lie. Why is it, do you think, the law puts a far higher premium on our ability to exercise choice over our possessions than it does over our ability to make decisions for our own bodies? Hasn't always been thus. If you went back to the Sexual Offences Act 1956, Section 3 created the offence of procuring sexual intercourse by false representation or false pretences. That offence stayed on our statute books for nearly 50 years before the Sexual Offences Act 2003 swept it away. It served an important purpose. It enabled prosecutors who were concerned that whatever conduct had taken place did not remove the consent of the victim to find an alternative home for the defendant's liability and to prosecute him for that offence. Why do I mention it? There's been a lot of talk, certainly on social media this morning, I've certainly had emails, about whether our proposal is overbroad, whether it's revolutionary, whether it proposes to do that which has not been done before. It's not any of those things. What we're proposing to do is to bring back into the law a form of offence that we were comfortable with having on our statute book for nearly half a century. We don't know why the Section 3 offence disappeared. There are lots of reports that were in circulation before the 2003 Act came into force. None of them shine a light on why that offence disappeared. It may be Parliament thought that it wasn't needed. It may be it was Parliament's understanding that consent within the 2003 Act would do the work that Section 3 had been performing before. It may be Parliament's thinking was that these aren't difficult cases that would typically be prosecuted under that section, and that any types of deception that's capable of taking away a person's consent to activity would fall within the non-consensual offences anyway. If that's what they thought, then they're wrong. And the reason they're wrong is because we know, as I'm sure all of you do, about the various controversial cases that have come to light since the 2003 Act was brought into force. The most recent of those, which I know many of you will be familiar with, was the case of Lawrence, a case concerning a defendant who deceived a woman into having unprotected sex because he assured her more than once that he'd had a vasectomy and therefore was not fertile. In fact, it was a lie, as he cheerily admitted to her in a text message the next day, and she was pregnant. She had to have a termination. He was prosecuted for an offence of rape, the Court of Appeal saying that deception that was perpetrated against her is not a deception of a type that took away her ability to consent to that activity, because it didn't have anything to do with the nature and purpose of the act, which was to have sex. It was a deception about, if I've got the words right, the quality of his ejaculate. As if it's a conversation about a type of wine after dinner, rather than something that was fundamental to the decision that she needed to take about whether to engage in that type of sexual activity with him. And I wonder whether those responsible for creating the 2003 Act, if they'd had the facts of a case like Lawrence in mind, might have paused before making the decision not to have a provision like Section 3 of the 1956 Act to ensure that defendants who commit deceptions of that type end up falling foul of the criminal law in circumstances where there is a genuine acceptance, we think, that that sort of activity ought to result in consequences like prosecution. But that's not the case. And so what we're proposing to do is to bring back into the law that which through oversight or misadventure was taken away from it, to create an offence that would enable people to be prosecuted where they deceive others into having sexual activity with them. Not every deception will qualify. only those that are important to the person deceived and which the deceiver knows to be important. So for anyone who thinks that any little white lie or half-truth is going to find them dragged before the magistrate's court to answer for their crimes, that fear is overstated. But if you know that a matter is important to the person with whom you want to engage in sexual activity with, and you are aware of its significance for them in making decisions for themselves about whether they want to have that activity with you, and you choose not to tell them, or you choose to tell them an untruth, then why should you escape the consequences of your actions for a deceit as grave as that? It's important to recognise that what we're proposing to introduce is an offence that requires subjective knowledge on the part of the defendant. It's not that you thought that it might have been important, or you were concerned or suspected that it might be a matter of some significance, but it will apply in those cases where you know perfectly well that the information that you have and that she doesn't is important to her decision whether to engage in that activity with you, and you decide without reasonable excuse to conceal it. It's important to recognise that within the ambit of the offence, not everybody who withholds important information to their prospective sexual partner is going to find themselves convicted, because there is, as I've mentioned already, a reasonable excuse provision that we've built into the offence itself. There has been a lot of discussion about whether it would be appropriate to have such a defence within there. There's been a lot of discussion about how we might frame it, phrase it. What sort of people do we imagine might escape liability because the excuse they raise is a reasonable one? We don't think it's right to confine the operation of that defence to any particular factual situation. I can't stand here and judge what a future case might be, what an excuse might be advanced, and whether that excuse might be reasonable or not. But we're alive to the comments that a number of people have made about whether an open-ended defence like that may give perpetrators of deceptive sexual conduct too much of an escape route from the consequences of their actions. Which is why in the body of the offence itself, what we've recommended is that there be a number of factors which tribunals ought to take into account in deciding for themselves whether the excuse put forward is reasonable or not. They will include a range of considerations, whether the matter withheld is of a personal or private nature, whether the conduct that you're intending to engage upon, which you know this person wouldn't agree to if the truth was known, might be harmful to them, whether revealing the truth might be harmful to you. These are important factors, we think, which any jury dealing with a case like this would want to reflect on with care in deciding whether the reasonable excuse put forward is one which the prosecution are capable of disproving, because we think it ought to be for the prosecution to prove that your excuse, if you have one, is not reasonable. But what will the effect of this change be? We don't believe that introducing a new offence into the Sexual Offences Act 2003 is going to bring about a wholesale change to the way prosecutions of those who lie their way into bed will work. There will still be cases where deceptions as to the nature or purpose of the act are sufficient to take away the victim's consent, with the result that you could be prosecuted for rape or the other non-consensual offences as a consequence of your deceit. But what it will mean is that drawing unprincipled lines between different factual situations will become, we hope, a thing of the past. If you think about a case like Lawrence, that wasn't rape, wasn't anything criminal. If, on the other hand, of course, the defendant had said that he would wear a condom in order to have sex, and then at the last moment took it off, so that sex ended up being unprotected when the victim thought that it would be protected, that's likely to amount to a deception as to the nature or purpose of the act, such as to render non-consensual that particular activity. What is the principal distinction between lying about your fertility and lying about whether you are intending to wear a condom during the act of penetration. And if we can't really identify one that enables us to say in one particular factual scenario, that's rape with a maximum sentence of life imprisonment, but on the other factual scenario, it's nothing at all, then the reason why we need a reform like this becomes patently obvious. It's not there to catch embellishments, exaggerations about wealth, job prospect, or sexual prowess. It's there to capture generally devious people who set about to trick people into engaging in sexual activity, knowing perfectly well that they would not exercise that choice in the way they did if a very important matter to them had not been concealed. That brings back into statute what we say the 1956 Act provided for. It enables a degree of principle to be re-injected into our sexual offending. It enables those who have been the victims of conduct like that to have confidence that the law is not going to draw unprincipled distinctions between serious cases. And it is an offence which we suggest will be prosecuted responsibly by those who are charged with that obligation. That's why we feel a reform like this is important. That's why we feel a reform like this is just. That's why we feel a reform like this is proportionate. And that's the reason why, after a lot of thought, deliberation, discussion, disagreement, we've come to the conclusion that a Section 4A, framed in the way in which we suggest it should be, is the best way of ensuring the fair, proper, and appropriate development of the law in this area. That all sounds like a submission that I would make to the Court of Appeal. So let me finish like this. We couldn't do any of the work that we do without the involvement of a lot of people who know an awful lot more about this area than I do. And I'm delighted to see quite a number of them sitting here tonight. This is undoubtedly a controversial area, and people will disagree. People will say the offence isn't strong enough, people will say that it's too weak. But what we want to encourage is that conversation to be had. This is not an issue that is going to go away. Law reform bodies in the past have looked at this, and it's all been shoved in the too difficult drawer. Well, we want it to come out of the drawer. We want to dust it off. We've shined it up. We've given it to all of you and said this is what we think an appropriate offence ought to look like. You will carry on that discussion, we hope. Agree with us or disagree with us. It's enough that you're talking about it. But we will commend this offence to government. We will ask them to think carefully about introducing it. And we think it will meet the demands of the modern age and do justice to those cases where people hitherto have been able to act with license, to lie and trick in whichever way they think best to achieve an outcome that is purely for their own gratification. You have been remarkably patient. I'm going to hand over to one of those people who will tell you more than I can about the real life issues that arise in cases like this and why a reform in this area is a very worthwhile endeavour. Harriet.